could forget the memories that quickly pass, 'cause I have found a path to shed back with heaven and hell. It only takes a spark for a fire to start. Won't hesitate, won't fan the place that is the way. We'll make our own future. I'm gonna reach that finish line, 500 inches at a time. I'll keep going, nothing can stop me. Na 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 na. They say that we're not strong enough, but I ain't never giving up. And I'll leave this future behind me. Na 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 na. I'll keep going, nothing can stop me. Na 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 na.
Well, hello everyone, and welcome to a surprise extra. Let me check audio on here, how it's doing. I see the bars moving, and it's moving in an acceptable fashion. Let's maybe turn it up a little bit. So I have some stuff that, as per usual, I want to get out of the way before Saturday, or stuff that needs to be maybe talked in a little bit more depth before Saturday, or stuff that I just saw that was really stupid today. There's one lawsuit in particular that files under that. I hate the glare that comes off those glasses, so we're not going to use them. And given by how I'm already breaking down the alcohol, you should know what some of these lawsuits are going to be like. We got some things today. We got a whole list of stuff. We've got the MMTLP stuff that I didn't get to Saturday. There's a whole bunch of lawsuits there, but they're pretty predictable. I mean, they're MMTLP lawsuits, so I'll tack those on at the end. We've got an update in the Lisa Cook situation. Most of you already know what the outcome is, but I figured we'd go over the order in full because we won't get to that probably Saturday. And then, of course, Donald Trump is suing the New York Times because being fair assessments that connect him to Epstein apparently make the Donald feel very sad inside. So we're going to go over that lawsuit. Tried reading that over lunch. That was... I'm going to need the alcohol for it. So, to kick things off, I'm sure we'll also go over this Saturday with the normal crew, but I can't. If I'm going to already be on, I can't go over this without having something to say about it, because I have utter and complete contempt for Trevor Milton. But he made this post to, was it today? I'm pretty sure it was today. Yeah, today. Where he said, the SEC has dropped their case against me with prejudice. 5 years of outright lies. Media corrupt prosecution, former Nikola executives and short sellers is finally over. Well, I mean, if your own execs are admitting that, yeah, you're a fraudster, shiesty piece of shit, then, maybe it might be true. Yeah, and he goes on and on. Of course, we have the so ordered here. Okay, so I want to get something out of the way. Congratulations, Trevor Milton. Congratulations on being lucky enough to be running a scam during the most corrupt presidency since Nixon. All right, you got fucking lucky that you gave millions of dollars to Donald Trump to buy your way out of a criminal conviction. All right? Let's make that perfectly clear. It wasn't that you were exonerated by new evidence. This conspiracy that you pretend exists does not exist. You gave Donald Trump money and he pardoned you. There is no amount of money, however, that will change the fact that you were found guilty by a jury of your peers. There is no amount of money that will ever change the fact that you are a convicted felon, convicted of felony wire fraud. You stole people's money by lying to them. There is nothing you can do to escape that fact. And no matter if the SEC ever sues you again, you will always be a felon in my book. I don't care if Donald Trump took his little fucking eraser and erased all the consequences for you. You are a fucking felon. Get over it. Anyway, now we got that out of the way, we can move on to actually fun things. Like the Lisa Cook case. So, as you all probably already know, that the appeal on that, the stay did not go over. The government lost on the stay. What we'll get to is the stay itself, the stay order itself, and the laughable, and I do mean laughable, amicus briefs. I love that they go completely unmentioned in this order. Not only, like, this is James Fishsticks is now 0 for 2 on federal courts giving a shit about his amicus briefs. He went unread in the DMs of both DC courts, and it makes me laugh hysterically that they have zero fucks to give for this fraudster who dropped out of college, stole the IP from his former company, and is now LARPing like he's some hotshot hedge fund manager. It just doesn't get any better, folks. So let's go. Oh, that's the amicus curiae. Sorry. Motions, leave, participate in the amicus curiae. Oh yeah, this is the order. Okay. Just figured I'd make sure. Aha! And it did it for me. Blew it all the way up. Probably because I've opened it before. I remembered. So this is just the general order setting things out. All three amicus briefs were granted, and the order was denied 2-1 on a split to the two liberal justices, and then the one dissent is from what was it? Katsas, yeah, Katsas, who's the I believe was appointed by Trump, but anyway. Garcia, Circuit Judge, joined by Childs. Let me skip over the background here. The Supreme Court has repeatedly held that public officials with for-cause protection from removal has a constitutionally protected property right. Let's see if we pass the background and end here. I guess they don't have that section barred off, so we'll just start from right here on page 2. The government contends that Loudermill and its progeny do not apply because they concern mere government employees, and that principal officers of the United States, like Cook, can never have property interest in their position. The distinction between employees and principal officers is undoubtedly significant in certain respects, but the government's categorical position is inconsistent with the principles underlying due process analysis, and so no cases support it. See, this is the part that was really funny. You know you're not going to do very well on appeal when you get right out the gate and the court is saying, yeah, and you have nothing here that supports how you envision this to go down. Consider first the long-standing focus of the due process analysis in this context. Courts ask whether the legislature had created a legitimate claim of entitlement to continued employment. The reason a status providing for-cause protection from removal creates a property interest is that it supports an objective basis for believing that the employee will remain employed unless they do something warranting their termination. Here, the plain purpose of providing for-cause protection was to assure members of the Board of Governors, national and global markets, that they do not serve at will and thus enjoy a measure of policy independence from the president. The government offers no reason why an official would have a lesser expectation of continued employment based on a for-cause removal protection because she is an appointed officer, even a principal officer, rather than an employee. Instead, the government draws on institutions about the nature of principal officers in general. And it is true that Supreme Court has held that nearly all such officers are removable at will. So it usually makes sense to think that such officers have no legitimate expectation of retaining their position. But in this singular case, the government has pointedly not argued that the president has unfettered removable authority over members of the Federal Reserve System and Board of Governors. Yeah, I'm glad someone was finally pointing out that contradiction, because it kind of went unanswered in the circuit court. Like, the circuit court went over things more broadly. It was like 40 pages. I'm pretty sure the two judges denying the stay, I think their opinion was like 10, 11 pages, and then Katz's went on for like another 11, 10 pages. So for how brief it was, it's pretty hit some notes that weren't covered and pretty much soundly beats the government's entire position up. To the contrary, the government concludes that Cook is protected by statute from removal except for cause. In due process parlance, that protection, if it does anything at all, provides a legitimate and objective basis for believing that Cook does not serve at will. Yeah. That's kind of why it says for cause. With the principle underlying modern due process precedent stacked against it, the government turns its broad language in inappropriate cases. The government relies primarily on Taylor v. Beckham. In that case, the Kentucky General Assembly resolved per the Kentucky Constitution a contested gubernatorial election. The losing candidate, who had been temporarily installed in office after the election, argued that the legislature's actions deprived them of their property without due process of law. See, again, I agree with the circuit, and I agree with the lower court, the D.C. court, that yeah, like what are we doing here with Taylor? Because it's an elected official. Obviously, they have no vested interest, like in the same, like in a property right claim, because they serve, like it's like being at will for the president. Like, you serve at the pleasure of the people who elected you, and if they don't keep you in office, well, fucking tough nookies. You don't get to stay in office. In that case, the court rejected the notion that candidates had any property interest in their positions. The government now seizes on this court's statements that public office is not property to argue that no appointment to the federal office, however structured, could give rise to a property interest, which is really dumb. The government overreads Taylor. Yeah, no kidding. Critically, the case involved nothing akin to the statutory for-cause removal protections. The only argument for a property interest was that the offices in question were both profitable and honorable. Taylor necessarily did not address the question we face here. Further, much of the court's rationale turned on the fact that the parties were seeking constitutionally established elective office, and that the election had been resolved in exactly the way the state constitution envisioned. You lost the election, dude. Ta-ta. The government's other two cases are also an opposite. Crenshaw v. United States involved a Navy cadet who, at the time of entering the Naval Academy, was statutorily entitled to serve without removal except for certain causes following successful certification. Before the cadet completed his training, Congress passed a statute permitting his early removal. The court held that the cadet had no vested interest in his office, of which Congress could not deprive him of. Crenshaw, therefore, simply holds that statutory removal restrictions created no vested interest against Congress's power to amend the statute. Yeah, if Congress decides to change the rules, then yeah, you could fire her. So in a better example, if the government was making an argument, if Congress removed Lisa Cook's for-cause, firing standard from the Federal Reserve Act, then yeah, then the government and the president could remove her without cause. But you would need to change the law. And that's what happened in Crenshaw. And that's the only thing it can possibly apply to. When Congress changes the laws, the old law is no longer applicable. And there's no vested property interest for the change in statute. So, that's Crenshaw down. Which makes it even more confusing to me why they even tried to reach for that, like it was going to help them. I guess when you're really desperate, you'll do some silly things. Butler v. Pennsylvania is similar. The question there was whether any vested private personal rights were violated when the statute when the state legislature passed a subsequent statute reducing the salaries of certain appointed officers. Again, if the legislature changes the law, the old law is no longer applicable. So there's no vested property interest because the legislature changed the definitions. That's totally different. Totally and completely different. Crenshaw and Butler thus supports the uncontroversial and inapplicable proposition that Congress could amend the Federal Reserve Act to remove Cook's for-cause protection without running afoul of the due process clause. Yeah, 100%. Again, if Trump doesn't like that she has for-cause protection, he can go to Congress and be like, change the laws. And he's got control of the House and Senate. And they clearly suck his dick and pretty much do what he wants. So, but I get the feeling it would not be very popular. The consequences of concluding that office with for-cause removal protections may invoke due process protections are limited for the simple reason noted above. Most principal officers are removable at will. If Cook were to, she would plainly have no interest protected by the due process clause. But Cook enjoys uncontested for-cause protection, so she does have such an interest. One judge of this court previously concluded that the Supreme Court's due process precedent suggests that an officer with removal protections would be constitutionally entitled to some procedural protections before removal. Further, requiring some sort of opportunity to respond would not be anomalous in this context. The Supreme Court has twice stated that if Congress specifies that an officer of the United States may be removed only for a certain cause, the officer is entitled to notice and a hearing. Given that Cook has a property interest in her position, she is entitled to some kind of process before removal. Loudermill. Before the court, the government does not dispute that it provided Cook no meaningful notice or opportunity to respond to the allegations against her. Yeah, I like how the circuit court immediately saw through the whole, President Trump did give her notice. He posted on the tweeters in the social media machine. No, that's not notice. And it's definitely not a hearing. They freely admit that there was no hearing provided. They try and say that, she was given notice and just didn't choose to respond. But, the circuit court immediately sees through that. You didn't give her actual notice. And, moreover, you didn't give her a hearing, which she could present evidence. The president had already clearly made his decision. Given that because Cook's due process claim is very likely meritorious, there is no need to address the meaning of for cause in the Federal Reserve Act in this emergency posture. As for the equitable factors, the government relies primarily on the Supreme Court's orders in Trump v. Wilcox and Trump v. Boyle. In these cases, the Supreme Court stayed injunctions prohibiting the removal of members of the National Labor Relations Board, Merit Systems Protection Board, and Consumer Protection Safety Commission. The court suggested that the distinct merits question in those cases, whether for-cause removal protections for these officers at issue are constitutional, was close. And in that context, the court stated that the government faces greater risk of harm from an order allowing a removed officer to continue exercising the executive power that a wrongful removed officer faces from being unable to perform her statutory duty. This case differs in material respects. First, neither Wilcox, Boyle, nor any similar cases involved a constitutional due process claim like Cook's, on which Cook is likely to succeed. That difference alters the equitable calculus. Cook's constitutional claim suggests only that the president cannot remove her without providing a constitutionally adequate opportunity to respond. The harm to the government in this case is better viewed as the inability to remove a for-cause protected official without following the Due Process Clause's basic dictates. Yet, in balancing the equities, we have held, in terms that squarely apply here, that the government may not prioritize any policy goal over the Due Process Clause. Yeah. The Constitution trumps your policy decisions. Sorry, not sorry. Everyone that has protections under due process, those protections supersede the whims of the executive, or even the legislature. Like, due process is the fundamental law in the Constitution. Well, not the. It's part of the fundamental law that is the Constitution. Let me clarify that a little better. That was really sloppy the first time. Second, Cook's role at the Federal Reserve differs in relevant ways from the role of the officers in Wilcox and Boyle. Most simply, unlike in these cases, the government does not dispute that Federal Reserve governors are properly protected from at-will removal. That distinct feature of this case matters. The government cites our observation in a case where the president asserted unfettered at-will removal authority that the government may be harmed by relief that requires the president to work with removed principal officers. We're about to get to the fun one that's really going to blow a bunch of people's minds. It is also not clear that the Federal Reserve did I skip over something here? Yeah. But here, the government agrees that the president may not direct the Federal Reserve policymaking decisions. So, the president doesn't work with her, or any members of the board, because they're an independent entity that crafts policy separate and apart from the president that the president doesn't have, control over. Also, they make a very clear distinction here. That it's not clear that the Federal Reserve wields executive power. Now, if you get out your handy-dandy little constitutional law books, or the Constitution, those little Constitution books in there, go look up and see which article of the Constitution the power to print and coin, the power to coin money is in. I can guarantee you it's not under the executive branch powers. So you want to take? I've eliminated one of them. I've made it a yes or no answer between the judicial and the legislative branch. Which do you think has the power to coin money? That's right. The Federal Reserve isn't using executive power. It's actually power that belongs to the legislature. Finally, Cook has been serving in her position continuously despite the president's purported termination. Yep. A little loophole there that, that the Federal Reserve said, we're going to wait and see how this pans out before we kick her out, which allowed for a little bit more continuity and allowed for this argument that really makes things a little bit more interesting. Given these unique circumstances and Cook's strong likelihood of success on at least her due process claim, the government's request for relief is denied. You can go over, both of these are basically I like the majority opinion, because it at least goes into a little bit more depth of stuff that even though that it was mostly comprehensive at the circuit court level with that 40-page order, they found a little things that needed to be more nuanced, and I appreciate it. Katsas is just rehashing government arguments. It'd be difficult to discern that he wasn't just a government stooge. That's my opinion. I know you shouldn't, piss all over a federal circuit judge, but you know what? I'm going to call a spade on that one. I know we'll probably go over this again on Saturday, but I can't help it. We're also going to put out the fish lips watch. How many times am I, when dealing with his stupid shitty arguments of James Fish Sticks here, is he going to be having the fish pursed lips or the fish mouth agape when I pause? And I'm not going to go out of my way to try and create the situation. So if you want to go over this, I guess put your guesses on how many times we're going to get the fish face out of Mr. Fish Sticks here as we go along. In fact, I don't want to spend all evening on him, so we'll speed this up to 1.5. Sounds good.
It's hard not to look at what Lisa Cook has done.
Also, I can't help it. I hate this when baggies do it. I don't like it when he does it either. What is it with this genre of doing selfie cam videos from your car while it is in motion? Like, I get it. He has a Tesla, FS, self-driving car. And second of all, you're supposed to keep your hands on the steering wheel, dipshit. But it doesn't make it any less safe, because he's supposed to be paying attention. Also just proves that, Tesla is really shit when it comes to making sure that their drivers are actually paying attention while in FSD mode.
For the last 48 hours and not be convinced that she is an incorrigible criminal, someone intent on defrauding.
Wow, that sounds like some fucking defamation right there. Neither you nor Pulte have produced anything that proves that she's a criminal. The investigation, by the way, that is still ongoing, has yet to turn up anything. So this whole situation of suggesting that she is a criminal, I hope when this is all said and done, she fucking sues you and takes every penny from your little fucking fraudster ass. In fact, you are more of a fraud than she is. At least on the way out of the door of her last job, she didn't run off with their IP and their own intellectual trading data, you fucking dipshit. As we went over last Saturday, that he stole from his company and then started parroting around in his own new fund, pretending like it was his own. He's already accepted default on that one. So, it seems like a lot of projection for Jimmy Fish Sticks over here to be calling Lisa Cook a fraud when he's already an adjudicated fraud.
Defrauding the court and defrauding the American public. So on Friday, Reuters leaked a document, a loan estimate document from Lisa Cook from May of 2021 that purports to show that this entire fiasco was contradicted.
It doesn't purport. It was a loan estimate document, and as all the, mortgage experts, of which you're not, have told you and Pulte, who is also not a mortgage expert, that if you are filing a loan estimate like that, it means that you are in the intent phase of taking out that mortgage, and that it had to have happened within the preceding, I believe it was 3 or 5 days before the mortgage is actually filed for. And the document had that it was a secondary residence. In fact, it was a vacation residence is what was used. So, yeah, it does kind of blow your bullshit out of the fucking water, doesn't it, Fish Sticks?
idea, the allegation that she had gotten 2 mortgages on 2 homes by both claiming they were primary residence, was a couple problems with that.
I mean, you're the only ones at this point alleging that she used primary residence on both of them, but, you know, keep going.
First is, who leaked the document? Who gave it to Reuters? Well, Reuters doesn't disclose. So it's called on background in journalism. When you share a document with a journalist, you share it on background, which means 2 things. 1, the journalist cannot report the specifics of the document, cannot quote verbatim. And 2, cannot disclose where it came from. Well, where would a loan estimate have come from? It's not public record. It's not filed with the government. The loan estimate came from Lisa Cook.
Or the bank. Did you ever think of that one, Hot Slick? Or the bank? Like, Lisa Cook probably approved it. Yeah, sure. But, like, why? What does it even matter? If it is an accurate document, like the way you're making this sound is that she sent them a false document. And you don't think that Reuters didn't go to the bank and double check that it was real? In fact, they went to several mortgage experts who did verify that was a real document. So, like, I don't know where you're trying to go with this.
A loan estimate is what you would expect from the credit union when you give them some preliminary details about the home you're looking to buy, what rate, what down payment, et cetera, et cetera. The loan estimate came from Lisa Cook. The loan estimate, that's like saying there's a story in Reuters about James Fishback's pay stubs, and where did they come from? They probably came from me. And so...
Okay, is that your big fucking gotcha? Is that your big fucking gotcha? Because if it is...
Let's address the first concerning point.
Like, that's like saying that, oh, well, we should disregard all the defense's evidence in a criminal trial because it came from the defendant. This dude, I swear, like, how does he even get spots on, well, I know why he gets spots on Fox News, because of shit like this. He's a fucking tool.
Which is, why is Lisa Cook leaking stuff to journalists? Why isn't Lisa Cook, if this evidence is actually exonerates her, why doesn't she post it on X? If this is such an exonerating piece of evidence, why doesn't she just post it?
Because they're her private mortgage documents, number one, and number two, like, why would it make any difference whether it was given to Reuters or posted on X? This sounds like an awfully salty person being really pissed that he's been proven to be a liar this whole fucking time. And he's just really mad that now he's been proven to be a liar. And he can't admit that he's a liar, a lying piece of shit. And so now he's making up a story to make it seem like he isn't a lying piece of shit who's defaming a Fed board member, a Fed governor, and he thinks that he should just be able to get away with it because he's a piece of shit.
Posted on X for the world to see. First point. The second point is the preliminary loan estimate was actually for the second home she bought. She got a preliminary loan estimate in May. Then she went out and bought another home. She refied a 15-year mortgage, declaring it was her primary residence in Michigan. After doing that, she then went out and closed on the second mortgage. 2 points. A loan estimate is only good for 10 business days for the obvious reason that if rates move, the interest rate market, the mortgage rate market moves, as it was in the spring and early summer of 2021, as the expectations for rate hikes started to pick up after a pretty nasty CPI report in March of 2021.
Can't even keep his dates straight.
That would not have been good anyway. And the second, and the most important part, is a loan estimate is definitely not good if you're also getting a mortgage on another property that you've not disclosed to the credit union who's giving...
Dude, she did disclose it. That's why it was a secondary property, dipshit. Like, he went and danced around in all these stupid fucking circles only to be trapped once again by the fact that he's a lying piece of shit and can't keep his fucking narrative straight.
Giving you the loan estimate on another property. And so she got the loan estimate in May. I'd have looked at it, by the way, and declared or suggested it was a vacation home. By the way, the term vacation home is not even a technical term in the housing market. There's primary residence, secondary residence, investment property, etc.
Right, which would make it what again, dipshit? A secondary home, or a secondary property, or even like a vacation home, which suggests that it might be an investment property. But it's definitely not a primary residence. We can agree on that, right, fish sticks? We can agree that that means that it's not a primary residence.
There's no vacation home is not a real term.
I love how he needs to create these vagaries to get around the fact that he just can't get around the facts of the document, so he needs to make up bullshit. Oh, well, a vacation home isn't a specific term. Yeah, but it means we can eliminate it as a primary residence, right?
And I suspect the reason why she hasn't given us the loan estimate and gave it to Reuters instead on background, which means Reuters can't disclose who gave it to them. And again, who could possibly have the loan document, the loan estimate, but Lisa Cook? Who else could?
I mean, her husband, the bank, yeah, might be most likely Lisa Cook. But again, it just sounds like you're salty that you were caught with your pants around your ankles. You were caught being a lying piece of shit. But I mean, for James Fish Sticks, it's pretty common practice for him to just be a scumbag. There's at least 2 court filings now in federal court proving what a fucking scumbag he is.
Could have it. Nobody else could have it. That's like saying, oh, the car estimate that I got was suggested the car was going to be used for business purposes. Well, who else would have the car estimate except me? And so this is yet another issue with Lisa Cook. If you weren't convinced before that this woman has been intent on defrauding and
again, that's a ballsy assumption. Like, you just expect that Reuters is just going to take the document and not double check it with the bank, double check it with experts, which they did, and confirmed the veracity of it. Again, you're just a salty little bitch that you got caught in a fucking lie. Who cares if it came from Lisa Cook? If it's accurate and factual, then who cares? Who cares if it magically and spontaneously appeared due to an act of fucking God? If it's an accurate document, who fucking cares? The only problem here is that you, Mr. Bitch Tits, got caught in a lie, and now you're embarrassed.
very least, has not been open and forthcoming with the truth. This little back...
Okay. At all times, she has stated that she did not commit fraud. And this case is not about whether or not she committed fraud. It's about if the government gave her due process when it was required by law under the for cause statute under the Federal Reserve Act, to give her proper notice and a right to be heard. That's all this case is about. And at all times, she has denied the allegations. And if your assumption is to be believed, has produced evidence, even though she has no obligation to produce fucking anything to any of us. The only thing that she has an obligation to is, 1, to the president in a for cause hearing, and 2, to any sort of criminal investigation. There is no obligation to show you anything, Jimmy Fishnuts. Not a fucking obligation anywhere. Again, it just sounds like you're very salty that you were caught in a fucking lie.
Backdoor media gambit to give it to Reuters, to leak her own loan estimate to Reuters on the explicit, on-background condition that they cannot publish the document itself. They cannot tell you who gave it to them, and they cannot print verbatim specifics. Should tell you everything you need to know about the kind of person that Lisa Cook
Salty
is, and someone who cannot be forthcoming with the truth. In fact, can be set out and hell-bent on intentionally deceiving the court. And by the way, on page 15, footnote 6, she cited this Reuters report as the latest piece of evidence, independent evidence, in her estimation, that she's exonerated. You know why? Because she can't file the loan estimate with the court, because the loan estimate is not a piece of information that exonerates her. This is how these people work. They use journalists, they use these weird methods, leaking it on the express condition, you can't report on it, you can't give the details, you can't publish the document itself, and then go around and turn and say, look, the media says I'm exonerated. The media says that this...
But the entire... it wouldn't matter if it exonerated her or not. It really doesn't. Because again, the entire point of this legal proceeding is not whether she's guilty or not. The entire point of this proceeding is, did the government give her proper notice and a right to be heard as is required under the for cause firing procedures? Did she get her due process? And she did not. That is the only thing that circles around the merits here. That is the only thing that is at question here, which is why he's got to go 5 miles out of his fucking way with his absolute nonsense that has absolutely fucking to do with nothing.
A loan estimate that suddenly appeared out of the ether, that this loan estimate exonerates me. That is not how you do business. Lisa Cook, with all due respect.
No, how you do business is you steal your previous employer's IP and work history, and then you take it with you off to your new firm and then claim it as your own. Whatever, dipshit. Whatever. Stay classy, James Fishsticks. Oh, wait, you never had any class to begin with. I know we'll get to this Saturday, and I know we'll have separate comments, but I thought it'd be fun to talk about a little article that Kabiko did on Substack, a app that not a lot of people really use anymore. Let's be perfectly honest here. I don't know many people who use Substack really that much anymore, but I do have a few people that use it that I follow, and they usually got good stuff. It's been a while since he's done something. In fact, I'm not going to go over the article word for word, other than I'm so glad, and it's about time that more people are willing to actually have a discussion about Bill Pulte and his PPP shenanigans. And the fact that Mr. Rich Boy, who's so rich and successful, apparently can't pay back a $50,000 PPP loan. And seems to have taken it out solely because he could, and he could get away with it, and he knew that he would never be required to pay it back. Essentially, stealing $50,000 from taxpayers. Of course, you guys know the quote that he said on my live stream, where he said he would do it again and again and again. And I'm sure if free money was handed out where he could rip it out of someone else's pocket and put it into his without having to work a single day in his fucking life, PPP Pulte would do it again and again and again, for sure. He loves stealing other people's money anytime he can. But yeah, you should check out this article. Makes some fairly good points. I'm glad more people are starting to check out this fact. And the fact that if you're, pulling in millions of dollars in your fund, then you should, I don't know, at least pay back the $50K to the taxpayer. Just a thought. Oh, we have reached this point, huh? We've reached this point. Okay. And yet another episode of the Donald Trump trying to run away from the Epstein files. We get this wonderful lawsuit. This would be defamation lawsuit number 2 on this whole subject against the New York Times. Oh, he's okay. So I tried reading this during lunch when it first dropped. I'm going to tell you right now. Oh, I'll get there. I brought some help for this because I was scrolling through and I was waiting for the actual claims and the actual charges in this case. And I was sitting there going, holy crap, can we get to the point? Like, it is in there in the rules of civil procedure. The Federal Rules of Civil Procedure says a short and concise statement. There ain't nothing fucking concise about any of this. So I bought a bottle of Screwball specifically to get me through this fucking shit. Because I was reading it at lunch and I just said, fuck it, no, I'm not doing this now. Be gone, Satan. Not necessarily directed at the president, but this lawsuit is fucking... Duh. Please, please, please explain how his first quote in this new huge lawsuit is something he campaigned on, I think, point 4. Oh, paragraph 4. Okay. 85... Oh, Jesus Christ. I didn't even realize it was... Is that right? 85 fucking pages? Who got time for this shit? I guess I do right now. We'll see how far we get. Well, like this whole opening horse shit of President trounced her and like, okay, like we're gonna grave dig the elections from last year. And this victory was remarkable for many historical reasons, including because Trump had to overcome the persistent election. I didn't remember that line, but I can already tell what we're in for. He said paragraph 4. It's no surprise. It came as no surprise when shortly before the election, the newspaper published on its front page, highlighted in a location never before, it's deranged. He just wants on record many times. Yeah. Yeah, I can believe that. Came as no surprise when shortly before the election, this newspaper published on its front page, highlighted in a location never seen before, it's deranged in... Oh. I bet the lawyers on this are like, we're getting paid. We are getting so paid, and that's all I care about right now. A quote about dismantling government institutions. Oh, I'm sure it's in here somewhere. Subject matter of this action: a malicious, defamatory, and disparaging book written by 2 of its reporters and 3 false and malicious, defamatory, and disparaging articles, all carefully crafted by defendants. Next page on 4. Okay, we'll get there after this paragraph 6. Oh, wait. Is the next page still point 4? Okay. 2 of its reporters maximum damage upon Trump, and all published in the highlight of the presidential election is the most consequential in American history, represented by a new journalistic low for hopelessly compromised and tarnished gray lady. What? Defendant's pre-election goal was to kill 3 birds with 1 stone. Damage President Trump's hard-earned and world-renowned reputation for business sex. That's a good joke. Can we scribble out that success part and put like failure? Anyway, in the process, sabotage his 2024 candidacy for president. Well, prejudiced judges and juries in the unlawful cases brought against President Trump, his family, and his businesses. But like, what? More off crypto than he did real estate, I know, right? With President Trump having won the presidency, defendants' goals remain similar and unlawful. Tarnish his legacy. Can we get to the specific? Okay, specifically. Okay, good. On September 17, 2024, Penguin published a false, malicious, and defamatory book titled Lucky Loser: How Donald Trump Squandered His Father's Fortune and Created the Illusion of Success. I mean, how isn't that accurate? No, it's just full of books. Books that he's really mad about. I'm going to tell you right now, I like that title. It is spot on. And then see, okay, I like that cover. That's well done. The whole thing is defamation. Well, it's a legal document, so they're allowed opinion, but this is silliness. In the lead up to the publication of the book days earlier, New York Times published a article titled "The Star-Making Machine That Created Donald Trump." Okay. So I assume they're going to talk about how he see that's the thing is like, yeah, it's initial filing, which is allowed to have some opinion. Like, they're going to have to support their opinions with facts if they want the case to survive. But, like, it's really hard to suggest that a court filing is defamation. Again, not a lawyer, so I'm not going to venture too hard in that. But, like, from what I've read of court cases, that'd be a tall order. But, like, I assume this article is about how he used the media to create his personal image, which, again, most people would just shrug that off as like, yeah, so what? But, I mean, whatever. October 2024, the Times published another article for Trump, a lifetime of scandals heads towards a moment of judgment. Okay. For Trump. Okay, why did we put it on there twice? Another election interfering salvo on October 22nd, 2024. As election nears, Kelly warns Trump would rule like a dictator. You know what? That isn't defamation. That's a fucking, like, prediction. Can we make whoever did that article, can we name them a vizier for their fortuitous powers to see into the fucking future? Oh my goodness. Like, that is not defamation. That is just a spot-on prediction. The book and articles are part of a decades-long pattern by the New York Times of intentional and malicious defamation against President Trump. Man, I hope they come with a lot of... On The Apprentice. With such an appealing target that they had no qualms betraying journalistic standards to push a fake story to help Democrats. Like, at what point are we going to get to, like, can we get to actual substantive argument here? Oh, here we are, the parties. We know who the parties are. Surely we'll get to some argument now that we're through the... Why are we spending more than one page on the parties? Like, this should not be more than 5 pages. What are we doing here, brah? What are we doing? Okay, there we go. Jurisdiction and venue. I'm gonna be a little honest here that I'm a little confused because New York Times, I'm pretty sure, is a Delaware corporation. Yep. So let's see, what are they going to do for jurisdiction? Are they going to do diversity? Okay. They're doing diversity jurisdiction. That's fine. I was a little... This is the type of court shit I wanted, this term, not questioning due process. Yeah, I know, right? But we're going to get plenty of this too. Don't worry. He seems to lie of him a good defamation lawsuit from the White House. So yeah, he's going to get diversity jurisdiction, which that's totally fine. I was beginning to wonder how he was going to sue a company based in New York and another one based in Delaware from Florida. It don't work like that unless you get federal diversity jurisdiction, which is what he's going to go for. So that checks out. Factual allegations. Oh, good. Let's hope there's some let's hope there's some actual facts now, as opposed to just arguments on their face with no factual support. I'd hate to have to break out Twombly this early in the game. 27 pages, and we're just now getting to factual allegations. This is a good sign. Not really. President Trump's late father, was a legendary business and a patriot who built over 27,000 apartments in New York. Yep, okay. Cool. President Trump's early successes in business acumen were nationally recognized in 1982 when he was listed on the Forbes 400. Look, you spent all that time talking about the parties. Why do we need to, like, rehash all this? Built and transformed. Okay, yep. Cool. Why do we need to list all the properties? Just say there's a lot. Why do we need to spend a page and a half on all... Take a drink. It's gonna be a long night. It's gonna be long. Again, why do we need to list all the books? What? I'm okay. President Trump has utilized his business and real estate acumen to grow his business holdings across America. Okay, cool. Like, are we just going to spend 10 pages just bragging? We did. Okay. President Trump's celebrity acumen paved the way for The Apprentice. Okay, cool. Please tell me. Okay, The Wrap made this article. I was about to say that if he created that, I'd be a little embarrassed. Well, I mean, these are good number polls. Until you get about to like 2010 here, after it drops off here, that's not so great. But these numbers up here are really good. Really, probably just should have stopped after, what is this, like season 6, or after the first Celebrity Apprentice, because after that the ratings just kind of die in a ditch. The illogical, tortured, and twisted fantasy of the book and the articles. Yeah, I know. If you're going to spend a bunch of ass loads of pages talking about the parties, why not just... And also, why did we need 3 pages, 3.5 pages, 1.5 to talk about all the properties? Just say he has a lot of properties and give a few examples of the most prominent ones. The same with the books. He's written a lot of books and then name a few. He's been on a lot of shows, movies, and on TV a lot, and then name the most popular ones. I don't see what we're doing here. Anyway, clearly indicating defendant's actual malice, the book and the first article center on the absurd, fanciful, and false story that President Trump somehow owes his public persona and celebrity status to Burnett and other NBC executives. I mean, to a certain extent, probably. Nothing could be further from the truth. NBC and all the producers are indebted to President Trump for See, I was about to say that there's a bit and parcel there. Trump's personality helped make the show, and NBC helped craft the show, and there's a bit of give and take there. It's like, nope, it was totally Donald Trump. It was the only reason that show succeeded. As conceded in the book, Trump was the star. Okay. One producer even observed that he couldn't have been a better reality star. I would agree. He definitely has the personality for reality TV. Take whatever from that statement you wish to. Indeed, the false thrust of the book and the first article, the twisted inversion of President Trump's importance to The Apprentice. Again, this just sounds like opinion. Like, someone looked at the situation of The Apprentice and came away from it with the opinion that Trump's persona is overblown. And most people who don't have a fragile fucking ego can accept that fact and move on with their life. Because it's one person's opinion. Who fucking cares? book in the first article revolves around the false, malicious, and defamatory premise. Again, also, how in the fuck did this even injure him in the slightest? He said that this came out to injure his election chances. Well, guess what? He fucking won anyway. So, like, what injury are we even talking about here? Like, that's the big thing with defamation is has to be false. Opinion is allowed. The truth always sets you free. There has to be an actual injury. And in Donald Trump's case, it has to be something that was knowingly false at the time it was said. Knowingly false and with the intent to cause injury. Or in some states, like Arizona, I don't know what it is in this case since we're doing federal diversity jurisdiction, so what's New York, Delaware, and Florida's laws on actual malice. But like as an example, Arizona's actual malice standard is it has to be a false statement that was knowingly false with the intent to injure, but if it is a sincerely held belief, then it can't be actual malice. So, what's an absurd thing that I can sincerely believe that would fall under this? I sincerely believe that, for example, George Bush caused 9/11, like not accidentally let it happen, like no, he orchestrated it. I sincerely believe that, therefore it can't be actual malice. Because it's not that I'm intentionally trying to defame him, I'm dumb enough to think that that's reality. So, I posted this on Twitter the minute I saw this lawsuit. I'm like, can we get federal anti-slap now? This is why. Like, state laws are cool and nice and all, but we need federal anti-slap for bullshit like this that comes into federal courts. Drew eyeballs and viewers. Okay, some more masturbatory paragraphs. Got it. Further underscoring the defamatory nature of this false premise, the producers of The Apprentice somehow made an undiscovered President Trump into successful celebrity, and the actual malice of Craig Brennan's opinions concede that. Wait, what? Again, you use that phrase, and I don't think you know what it means. The actual malice. Like, does he actually think actual malice is they say mean things about me, therefore they're being malicious? Is that what I'm supposed to take away from here? Because again, opinion cannot be defamatory. If they look at something that are verifiable facts that, you know, Donald Trump and The Apprentice and as an NBC show was successful, but most of the success could be attributed elsewhere in certain aspects to Donald Trump, but some of it, or the majority of it, wasn't Donald Trump. That's an opinion. I'm confused as to like what do we want? What are we trying to do here? This paragraph, the unattainable, tortured logic laid bare. They claim that on one hand, The Apprentice magically transformed President Trump from an unknown businessman to okay. I think that's being a bit much. Let's go back up here. The revered CBS program 60 Minutes had been working on a profile of Donald. A producer of the show later recalled that the segment came out about originally from the supposition that Donald Trump seemed to be everywhere. Known for his tough scrutiny of subjects, correspondent Mike Wallace opened the segment by lending his voice to Donald Trump's favorite version of himself. In a world where mere millionaires have become a dime a dozen, Wallace said, there's a new billionaire in town. Trump's the name, Donald Trump. The most serious news program on national television had just crowned Donald Trump a billionaire. I mean, I think like the book admits that Donald Trump was famous before it happened, but the argument is to say that he became as famous as he is now specifically because of The Apprentice. Like, you're not going to find someone in my age demo, like millennials, especially since the millennial demographic doesn't start till 1985. So nobody in my generation, and especially not the generation that preceded mine, Zoomers, are going to have a fucking clue about this 60 Minutes interview. They're not. They know Donald Trump from The Apprentice. Like, maybe Gen X and probably my parents' generation would know that, have some realization of Trump from his casinos that he ran, the fact that he owned a USFL franchise, and all these other things. But, like, the vast majority of Americans know him as the business tycoon that also was The Apprentice. That was his big thing. And I get the feeling that's the argument they're making. It's not that Donald Trump wasn't already famous, but the reason that he's as famous as he is now is because of The Apprentice. And there's no fucking way to deny that. It's just that's just objectively true. I don't know if that's what's being suggested, but what he's trying to say is that, he was famous enough to be on 60 Minutes in 1985. So he was clearly it wasn't just The Apprentice that made him famous, which I'd agree with. But you can't deny the reason everyone knows who Donald Trump is, aside from that he's president now, is because of The Apprentice. The biggest and best. The alarming level of intellectual dishonesty and the lack of... okay, so here we are. Like, they're not saying that he magically became famous because of The Apprentice, but, like, again, seems like we're really reaching here. Paragraph 74. The alarming level of intellectual dishonesty that's going on in this lawsuit. Oh, I'm sorry, they're talking about the book. Several pages later, Craig and Penguin... Can we just, like, initial it? We're just going to initial it from here on in. Anytime he brings up Craig, Bunther, and Penguin, I'm just going to call it CBP. CBP. For the first months of 1985, the Trumps flew back and forth between Florida and New York most weekends. Donald and Ivanka. Okay, what are we trying to prove here? Did I miss something? Several pages later, CBP reported about the legendary Robin Lynch to visit President Trump at Mar-a-Lago. Okay. The defense themselves proved that their other false claims are malicious. What? CBP conceded that in 1986, Trump had been transformed from a real estate developer into a national celebrity. People stopped him on the streets of Manhattan for an autograph. Some asked to touch him for good luck. Okay. Like, again, I don't think they deny that he was that Donald Trump was a celebrity. They're just saying that the reason he's this superstar celebrity is I also still don't see how this is, like, harmed him in any way. Another highly inconvenient but material fact buried by CBP deep in the middle pages of the book, just before Robin Leach's visit to Mar-a-Lago, puts the lie to their attacks on President Trump's business acumen. President Trump acquired Mar-a-Lago for a total of $8 million for the state contest, plus another $2 million for $400. Yeah, okay. Down payment of $2. Yeah, okay, whatever. Florida is likely well worth $1 billion. Indeed, Mar-a-Lago has more than 10 times the acreage of the property and holds the record for Palm Beach's most expensive home. Okay. Is there is there a point? What was the point of that entire paragraph? And years later, even the antagonistic Baker conceded the pages of the New York Times that the President Trump had been a celebrity builder before. Again, where is the fucking point? No one's denying your celebrity. They're just saying that what made you a superstar was The Apprentice. Like, what are we doing here? And even then, again, how did this injure you? Hanging the insult to injury, the book in the 5th article falsely painted Trump's affable personality, which Bennett had found so appealing, in a negative light. Defendants were surely aware of prior efforts to involve Trump in reality-themed programming, such as HBO's Ali G show for The Apprentice. Okay, and how many people, show of hands, remembers that? I thought so. Like, again, no one's denying you're a celebrity. No one denies you were a celebrity before The Apprentice. But again, the main reason people know you is The Apprentice. It's like saying that, Gordon Ramsay is a celebrity chef. He's well known. But the reason everyone knows who he is because of Hell's Kitchen and Kitchen Nightmares. Anyone disputing that fact is a fucking idiot. Defendants individually and collectively. Okay, let's see what false statements. There, we're going to get to the meat of this. Penguin Craig Butler published the following false statements in the book, among others, without limitation. Okay, well, this is their top 10 list, I guess, or something. Donald Trump had received the equivalent of more than $400 million from his father, much of it through fraudulent tax evasion schemes. At the time of publication, CBP knew that President Trump had not received any money from his father through fraudulent tax evasion schemes. Well, I hope you got more to prove that than just your word. But okay, it's a complaint. It's a complaint, so we again, we have to deal with the Iqbal Twombly standard of well-pled facts are what the court will accept. And so, cool if they prove that this is false, but they can't just say it's false, trust me, bro. The court's not going to accept that. So, hopefully at some point they show how it's not false. The family fortune that launched Donald Trump was built on government programs designed to ease the pain caused by the Great Depression and World War II and to assist the veterans returning from war. His father wrung millions of additional dollars from those programs by twisting the rules. Wouldn't be surprised. And to be fair, probably not the only person who did. So, a reasonable reader would have understood these statements as asserting as a matter of fact that Fred Trump violated federal law to wrongfully benefit from these programs. No. Twisting the rules doesn't mean that you broke the rules. It's like bending the law, bending the rules. It's technically illegal, but what you did is morally reprehensible. So, no, that sentence doesn't do it for me. That they're accusing him of breaking the law, because that is not what that sentence says. Nice try, though. At the time of the publication, CBP knew that President Trump's fortune had not been built on violated federal laws regarding any... Well, again, they're not accusing you of bending or breaking the laws. They're accusing your father of bending the rules, of twisting the rules to take advantage of the programs. And at no point did they say that any laws were broken. So, no. Mark Bennett, the television producer who made Trump a star, did not just hand him a fortune. Skilled hands created a version of Donald Trump, diligent, master, polite, but authoritative that may have been non-existent but was highly marketable. At the time of publication, CBP knew that President Trump's presence on The Apprentice fairly depicted how he conducted... No. No! If you believe that, you just might be an idiot. Like, everyone knows every part of any reality TV show is heavily scripted. Like the fact that it's called a reality TV show is a misnomer and a marketing trick. Most reality TV shows are heavily scripted. The personalities are created and crafted just like any character in any narrative would be. The idea that he's trying to sell in this lawsuit that a reality TV depiction of him is like, he probably had those characteristics, you could say, but they were definitely enhanced, or that the program was edited in such a way to enhance those characteristics and to set up specific situations in which those characteristics could be shown. Like, how stupid does he actually think a judge is? Because no. I wish I had Joey right now, because he'd be so much help, because I don't do this reality TV stuff. Yeah, I'd agree there. He has said that The Apprentice was his biggest and best. Yeah. True facts. Sometimes, despite himself, Donald Trump received his fortune from those sources mostly outside of his ability to run a business. The secret of his life, one that emerges in hundreds of moments, big and small, is that the less he has been involved in decision making, the better the chances of financial success. I mean, he did go bankrupt multiple times. And that's not to say that you can't go bankrupt and become successful. The whole point of bankruptcy is restructuring so you can try again and actually succeed. So I don't say that like bankruptcy necessitates that you are not successful, but there have been projects he's done that are inarguably unsuccessful. Let's put it that way. It was the first of many such relationships in Trump's life. He would be drawn to men who displayed a penchant for violence and waxed sentimentally about the days when his perception society accepted resolving disputes with physical violence. A responsible reader would have understood the sentiment as asserting, as a matter of fact, that President Trump No! That is such a leap of logic. It says that he would be drawn to men who displayed a penchant for violence. Never said it was illegal. And would wax sentimentally about the days when his perception, societally accepted, about resolving disputes with violence. No. Like, duels used to be legal. They aren't anymore. But it's not saying that he went out and shot people, but he definitely had the opinion that if he had a dispute, both men should take 20 paces, turn and fire. Like, as an example. Not literally, but as an example. Like, if you have a dispute, we're going to go outside. And it's not going to be like Bill Pulte going, oh, to talk? No. I mean, we're going to fisticuffs, and both of us are going to have a better respect for each other after we've bloodied each other's noses. But none of that is necessarily illegal. These lawyers either have a lower IQ score than I could possibly imagine would be required to pass the bar, or they are playing dumb for a paycheck. I'll let you decide. Tenants at the Pembroke and Hague Towers blamed Trump for the infestation of cockroaches and mice, broken air conditioning systems, elevators that did not work, a lack of hot water, and an unusable swimming pool. A reasonable reader would have understood this statement both as a statement of fact regarding the conditions, as well as a statement of fact that the Trump family maintained a low quality, But again, it's an opinion based on collected testimonials from people who lived there. So, I mean, have fun with that. With no real estate or financial staff at his disposal, Donald's assessment of a potential opportunity started and stopped at the end of his nose. There would be no deliberative planning and very little in the way of an analysis of risks or potential return on investment. A reasonable reader would have understood this statement as an assertion that President Trump neither conducted nor participated in reasonable diligence before making real estate investment. Yeah, I will give them that one. But again, how do we separate the idea that this is an opinion from fact? You need to go more than just the statement. You need to go what precedes and succeeds the statement. Like, you can't just like cherry pick that there. Is it a factual statement based on diligence that they have done? Like, you can't just put a statement in a vacuum and say it's defamatory. There needs to be a lot more work here. The language in the tax code, Fred had given his sons taxable gifts, masquerading as loans, a likely tax fraud that went unnoticed. I mean, that's pretty common. If they're going to suggest that that's defamation, I could buy that, though, because it's not fraud. It's tax evasion. And then there is a difference. Like, tax fraud is legitimately breaking the law. Tax evasion is when you do something that is within the rules that is deliberately designed to avoid to have to pay taxes. Gifting out things to people, but expecting it to be paid back, which technically is income that should have been taxed. So, I guess again, you could see that as tax fraud. So, like, this one's kind of 50-50 for me. I can see if you could see this as defamatory, but again, you'd still need to prove injury from this. But at the other way, I can see where you could legitimately consider that tax fraud, if indeed it is a loan that is to be paid back. That is not a gift. You cannot use that to evade having to pay taxes on. Oh boy. Even as his father's chosen successor and the child who benefited the most from his father's wealth, Donald accelerated his long efforts to erase his father's accomplishments from the public consciousness in service of artificially inflating his own. At the time of publication, CBP knew that President Trump cherished... Okay. It seems more like opinion-based, but cool. He increasingly saw no value in working with partners or in heeding the advice of others when prominent business consultants, experienced sports team owners, and executives with one of the best-run hotel and casino companies on the world. A reasonable reader would have understood the statement as an assertion that Trump was not a willing business partner. I mean, his presidency has been pretty good proof that he's not willing to work with people. It's my way or the highway. So, I mean, sure, if you want to make that assertion, but I don't buy it. As the national economy slowed, Trump took on costs and debts with breathtaking speed, each time without seriously running the numbers to spec out potential profits. Neither conducted nor participated in regional diligence. Again, I need to see more that led to this conclusion. Again, we're seeing these little snippets, but we're not getting to see how they came to this conclusion, because on its own, sure, you can make a reasonable suggestion that maybe that's defamatory, but unless we see the work that went into that conclusion, I can't conclude that it's defamatory. Maybe they do have facts and evidence that support that. but we don't get to see them in this petition, in this complaint. They're nowhere to be found. So, like, again, is this like based on nothing or based on actual research they did? I'm going to believe, considering it's in a book that was published by a publishing company, there was probably research that went into that. That was in the book. I'm not going to just buy the book to find out, though. That's their job. If you're going to write a lawsuit and say it's defamatory, you better prove out your shit. During a 15-year rise, he had paid close attention to aesthetic details from the waterfall and ficus trees in the lobby of the Trump Towers to the angle of the telephone handsets on his yacht for high rollers. He had not paid similar attention to the financial details, especially whether his individual businesses could support their payments on the money he borrowed to buy and build them. I mean, look at his renovations to the White House, where it's all about gaudy facade over actual... Yeah, I would believe that statement. At the time of publication, CBP knew that President Trump paid appropriate attention. Again, this is just assertions. These are just assertions with no factual support. And they're not going to pass the mustard. I smell a motion to dismiss right around the corner. This feels like I'm reading one of these fucking MMTLP lawsuits or one of these meme stock lawsuits rather than a lawsuit from actual lawyers filed on behalf of the President of the United States. To put it more bluntly, do better. A plan was soon devised to funnel some of Fred's cash to Donald and his three siblings. They would accomplish that goal by adding a sham layer to Fred's business, one designed to evade the gift and estate tax. They would call this extra layer All Country Building Supply and Maintenance. It would serve no purpose beyond creating an off-ramp to send cash to his children. I would agree that a reasonable person would believe that the assertion here is that that Donald Trump's father, Fred Trump, violated federal tax law to basically funnel money to his kids. If there's factual assertions for that, cool. But also, again, Donald Trump is a public figure, and he's going to need to prove actual malice, and he's also going to need to prove that there was actual injury to him, which, best of luck to you. So the Trumps began submitting the padded bills to request rent increases from state officials. Part of the cost of Trump's off-the-books inheritance would be passed along to his father's middle-income tenants. Statement explains on how the Trump family committed criminal tax evasion and defrauded state officials, their tenants, or both. Yeah. But again, it's your job to prove that these things are false, and you haven't done that. I'm going to assume, like, we're on page 32. Again, oh, I forgot, this is 85 fucking pages. After experiencing years of sensory overload in jungles around the world, first thing Bennett's producers noticed is when they arrived on the 26th floor of Trump Towers was the sink, a musty and moldy carpet smell, and it seemed to emanate from every corner. As they walked through, their eyes noticed small details. A reasonable reader would have understood this statement to be both communicating specific flaws of Trump Tower and its 26th floor, as well as asserting the statement the fact that Trump and its 26th floors. Why do we need to be specific? At the time of the publication, in general in particular, so we're in excellent condition. You can't just assert that. You can't just assert that. You have to prove. Like, no court is going to accept on its face just mere statements and assumptions. Trump's desk showed no signs of real work, no computer contracts or files. It was just smothered by newspaper and magazine articles focused on one subject, himself. Yeah, I could believe that. Understood the statement as asserted that President Trump did not actively participate in his business. I mean, maybe. Also, it's at that point in time that he was there. That is also key here. We don't have, like, it's just the sentence, and then the assumption at its face that Trump draws from it. Beyond the studio space, the harder work of renovating Trump had only just begun. A reasonable reader would have understood this as a statement of fact that President Trump's typical demeanor would have made him unfit for serving as the host of The Apprentice. I don't think that's what's being said here. And again, it's just one sentence taken wildly out of context. Like, renovating what about him? His appearance? Sure, they do that all the time. How he's supposed to act on camera? Yeah, there's probably a director. Like, what are you trying to say here, bro? Because this just... Trump, the self-described world's greatest deal maker, had sold the bulk of his father's empire for almost $250 million less than it was worth at the time. Care to show us? Like, again, these are just statements that are made on their face, and he doesn't care to prove them out at all. Do we keep going like this? Yes, we do. Okay. Now we're on to the New York Times. Published the false statements in its first article. And so, let's see here. In December 2023, a team of television producers stepped off the elevator of the 26-foot Trump Eagle to survey the set of their newest reality show. For years, the filming survived. Okay, that's the same statement again. Okay, whatever. Spiritual Center, Trump's own desk bore no evidence of work. Okay, that's that one repeated again. Tycoon and television, Mr. Trump secretly put in a plan in motion to tap into his father's fortune again. I mean, maybe you could say that that was defamatory, but again, how did it injure you? I'm becoming progressively just... the same problem I had when I looked at this at lunch. It just goes on and on and on and doesn't prove very much, if anything, and just... Trump would need only to play a recrafted version of himself. Said this is a statement of fact that Trump's typical demeanor would have made him unfit for... No. It's not saying that he wouldn't have been... It's not saying that he wouldn't have been unfit. If he wasn't unfit, they wouldn't have hired him. But a TV personality is not the same as the actual person. Like, any adult who has had 5 seconds in media knows this. I find it hard to believe that Trump deludes himself into thinking any different. The producers would also need to invent a version of Donald Trump that did not actually exist, measured through an endlessly wealthy and completely rehabilitate his public image. I mean, did they? I could see the part of the rehabilitation part maybe, but again, like, The Apprentice's highlights, like the high end of The Apprentice was what, early 2000s, before the great financial crisis. Like, again, most people my generation, if you said Donald Trump and pointed him out, yeah, sure, probably knew him. But, like, knew him, like, post-apprentice, not likely. At most, my generation would know him as the guy who is in Home Alone, who had the swanky hotel in New York. Like, that is the extent of the consciousness of Donald Trump, whether he was rich or successful. Boop. But again, that could be something that, if you put more factual support into it, you could say was defamatory. But again, we have the problem of, how did it actually injure you? And also you have the actual malice standard, which, while we're here, why don't we do something? Reckless disregard for the truth. Okay, they're going to go back to the... Okay. Yeah, that's what I want, the New York State statute. Probably wasting my time, but it saves me from having to read that god-awful lawsuit. So let's try and figure out what New York statute, because we need to know what New York, Delaware... This is a good enough one. Is it not in here? It doesn't define what actual malice is. Well, that's cute and unhelpful. An action involving public petition or participation is a claim based upon any communication in place that would nowhere. Private matter. I mean, any statement, claim, or allegation of proceed any other lawful contact for that extent of the constitutional right of free speech. Action involving public participation based upon an action involving public participation. Okay, well, not helpful. Well, it was worth a shot. Publish the following false statements in the second article. Okay, are we done with the supposed false statements? Okay, cool. New York Times knew better than to publish Kelly's obvious Hitler lie. After all, in 2017, the Times reported extensively that President Trump's historic decision to recognize Jerusalem as the irrelevant. What was the statement here? Admiring statements. Like, you can... Contempt for disabled veterans. Yeah. Like, that is like a non sequitur. You can make stupid statements like that and still do this. These are two things that are separate and apart from each other. Like, are we still... Defendants doubled down and refused to retract their falsehoods. Okay, I assume that they got retraction notices and told Trump to shove it up his fucking ass. Defendants' actual malice towards the president. Alrighty. Let's see where they get us. Defendants each desire for President Trump to fail politically and financially. That's not what actual malice is, but keep going. Each feels actual malice towards... That's not what actual malice means in the legal sense. Each feels actual malice towards President Trump in the colloquial sense. But that's not what actual malice is in the legal sense. What? Make the stupid stop. No one needs to speculate as to the extent of this hatred. The Times admits that it views President Trump as a... what? And as a result, the far-left newspaper has worked tirelessly to... What the fuck is this? That's not... Actual malice is statements that were made that were known to actually be false, and they were made anyway with the intent to injure. Key emphasis on the intent to injure, but like that, like you can make statements that you can have like colloquial malice, like you don't like the president, but that doesn't change the fact that if the statement is true, or the statement's not true and was stated erroneously with due diligence in mind, because again, you can make statements that are what am I looking for? That it'll come to me later at the most inconvenient moment. Reckless disregard for their factual nature. So there has to be some level of like actual culpability to it, but like it doesn't matter if they actually have ill will to you. That's not what actual malice is. And they ramble on, I bet, about how much the New York Times just fucking hates Donald Trump, right? Number of ways defendants launched investigations into Donald Trump, his family. That's not... Of course, if they are doing a book and articles, they're going to investigate the... to engage with... Defendants deliberately refuse to engage with individuals expected to speak well of Donald Trump and his business. Okay, and if it's all truthful, it doesn't fucking matter. Like, this comes, like, you guys are professional lawyers sitting on the bar. You have to know this is not what actual malice is in the legal sense. Have to know. I refuse to believe you don't. This is idiotic. Times and its reporters do not believe that they need to cover President Trump fairly. Irrelevant. Fucking irrelevant. And post-next Americans will finally learn the truth of the 2016 intelligence was politicized. How intelligence was politicized, weaponized by the most powerful people. We're gonna quote Tulsi Gabbard as if she's a source of factual information and not a total puppet of your administration because she works for it. I mean, while we're here like complaining about the New York Times allegedly self-selecting for bias against you, it sure sounds like you're self-selecting for people who have a vested interest not to say bad shit about you. Dear Pot, stop calling the kettle black. You are too. I really don't care what fucking Tulsi Gabbard says. What is with all these fucking articles? I also hate how this happens in federal lawsuits. I like clean orders like I saw in Delaware with the Delaware Court of Chancery, where the vast majority of shit was moved to footnotes so I could read the clear argument and then I could go to the citations for those arguments. Cluttering up the fucking argument with all these fucking citations annoys the shit out of me. I hate it. I hate everything about it. Stop it. Stop. Also, I'm going to take a few tags out because I thought what this lawsuit was going to be out was something, and it wasn't. I'm sure that's why I'm getting pop-ups of people coming in, seeing what this is about, and then going, oops, that's not what I thought this was about. And so we're going to hit that. I'm going to save that. Just going to update some tags here. There we go. Fixioed. Oh my goodness. What now? Oh, damages. Oh, good. Well, I'm going to get a refill before we get to damages, because I have a feeling I'm going to need it. Why not also throw some popcorn in, because this is getting good. Defendants' defamatory and disparaging statements have caused numerous harms to President Trump and his business. I'm skeptical, but continue. Ooh. A little off the top there. Peanut butter whiskey. Fucking delicious. Screwball is great. Anyway, Americans voted in historic numbers for President Trump, including determinatively in swing states. Yeah, which is why I'm having trouble trying to figure out how you were damaged in any way. Way to shoot yourself in the foot there. The reputational and economical harm that defendants have inflicted on President Trump and his businesses can be redressed by this court. I missed the part where he said that there was any... What was injured? Turned their publication high election. Defendants have also used their false and defamatory publications to disparage the American dream lived about by French. Still waiting it for here. Where? Discrete economic harms resulted from the defamatory statements. Okay. Defense timed the release of the book and the first article to be close in time with the release of the trailer for the forthcoming movie, The Apprentice. Okay. Defendants' false publications about President Trump also led directly... They published them around The Apprentice because they were articles about his... The book was about how Apprentice made him what he is today, and that everything else is just kind of not very well in comparison. Like, what made Donald Trump famous was The Apprentice. That was the entire point of the book. That he got lucky with The Apprentice, and that he was a celebrity, no doubt, a businessman, no doubt, but Apprentice made him the well-renowned star that everyone knows knows him as. That was also what the article was about. So, yeah, of course it was going to be timed around the movie. Also, what did that movie gross or whatever? Or is it even... Oh. The Apprentice film. Budget 16 million with a box office of 17.3. Grossed 4 million. Okay, so it was kind of meh. And the reviews were also kind of meh. I mean, Rotten Tomatoes said 83%, so I guess that's not too bad, but like the average rating of 6.9, that's kind of a little, like, given, like, I'm used to the rating scale of like 5 is meh. But, like, we've had it kind of more align along, you know, how you're graded in school, where, like, 70% is a C. So that's a movie that's slightly below average. It says Pulte gave the average of a B to A plus, B minus on the F. Okay, so, and then Surveyed Polytry gave it a 71. So, yeah, we're talking about a film that was kind of meh. And the money it made was kind of meh. So, like, this feels like a reach. Led to the decline of... No! They are not. No. Okay, look, I'm going to get the popcorn. I'll be right back. But no, that argument's bullshit. Now, what led to the decline of Trump Media Group's stock price, known as DJT on the stock market, is that was overhyped nonsense. This is a stock that is pre-earnings, makes infinitesimally small revenue, and it was trading at $100. Between the price range you see there at the beginning, where it was trading at, you know, this was, you know, before the de-SPACing, traded up here. Well, that was like back when it was SPAC, actually. Then up here, you know, you see it clearly. You get up to 61, and all these prices up here. Like, this is a company that's like pre-earnings, has revenue that's infinitesimally small. Like, it's a business that's still in development. I'm not saying it can't, or that it can't succeed. But let's be perfectly fucking honest here. The stock declined because the bubble popped on it. Pre-election, it was a gauge to gauge support for Donald Trump. Once he got elected, the fundamentals kind of took over. And let's be honest here. At $17, it's still overvalued. And since this is a mostly financial channel, I will be more than happy to stand on my laurels of that statement. I mean, let's pull up Yahoo Finance if you don't believe me. Can we get, oh yeah, there's the financial statements. Total revenue. Now, on most financial sheets, like, you'd see all numbers in whatever. So all numbers are in thousands. So as a trailing 12 months, their revenue for the past 12 months ending their last quarterly report. So this is in the thousands. Let's pop out the calculator here. So 1,000 times means their total revenue. Like, this is top line revenue is just $3.7 million. Like, there are individuals who make more money than this company does. Like, this is sad. They have operating expenses of 154 million. Like this is a company that is not doing well because it's still developing. The social media platform that is Truth Social under Trump Media is still a developing company. So, like, no, these statements did not injure Trump Media Group. Trump Media Group and its failure to deliver on its business model is what's hurting the stock price. It's such a fucking absurd statement. Oh. How low can we go? Let's update some things here. The value of Trump's one-of-a-kind, unprecedented personal brand alone is reasonably estimated to be worth hundreds, thousands, 100 billion. Trump's brand alone is worth 100 billion. I'm going to need a citation for that. That is absurd. That is absolutely absurd. Okay, finally, we're to the claims of relief. We're almost done with this. We made it, boys. We made it. I don't know if my sanity's still intact, but... Well, the previous 130 paragraphs are reasserting claim defamation. Defamation per se where? Oh. Well, at least they gave these specific paragraphs rather than trying to say that all of it was defamation per se, but whatever. Defamation per quad. Okay, good. They separate them out. I will give them brownie points for that. But on counts 1 and 2, contemporaneous damages in the amount not less than 15 billion? You fucking serious? No. And of course they want that, yeah. Punitive damages as well, cool. And they want lawyers' fees. I hope all of you are happy with the paycheck you're getting, because the hit to your reputation, like, I'm going to have to ask if it's really worth it. Because, man, the three of you look like the biggest fucking idiots. I hope it was worth it. Oh my goodness. That lawsuit scarred me inside. That was dumb. That was very dumb. Anyway, to wrap us up, and I'm going to try and make this quick. We have some MMTLP meme stock lawsuits. See if any of them have updated in the time being. Because I don't want to be up too late. First up, Scott Trout had a really big hissy fit last week about his case. The judge just foreclosed any possibility of amending the complaint and said FINRA had absolute immunity. No shit. They've been telling you guys this for like 2 years now, 3 years now, these courts. FINRA has absolute immunity. Like, this is a no shit moment. Everyone's told you this. A U.S. judge, just like all others, is defending an unelected, unaccountable, self-regulatory organization. Again, if you don't like the structure, elect people to change it. Stop being a bitch. Judges can only interpret the law as it exists. And if it says that they are immune, then they are immune. Eat a bag of dicks. I will be filing an appeal to the Second Circuit Court of Appeals within 30 days. Well, we haven't seen the appeal here yet. So we shall see. But also, the court's opinion on this is pretty straightforward. And I agree with it. Motion for extension of time, 90 days, to file a motion to amend the complaint against defendant is denied. Plaintiff alleges a number of grounds for continuance, including his other litigation commencement and his status as an on-duty United States sailor. I believe he's like a fisherman or something like that. Defendant FINRA opposes the extension, arguing plaintiff's request is not supported by good cause and is futile. On November 19th, the court dismissed plaintiff's claims against all defendants except defendant Charles Schwab, who he was sent to arbitration with. On December 16, 2024, the court granted Schwab's motion to stay this action against it and refer all plaintiff's claims against Schwab to arbitration, as I previously stated. Plaintiff filed a motion to file a second amended complaint, which the court denied on June 30th, 2025. Plaintiff was permitted to petition the court for further leave to amend and was directed to follow the court's local rules in doing so. Plaintiff has had more than 2 months to petition the court and seek an additional 3 months for a total of 5 months. Against this backdrop, the court agrees plaintiff has failed to demonstrate good cause for a 90-day extension. You don't follow the rules, the judge is just not going to, that's how courts work. There are specific rules for a reason. If you can't be bothered to follow them, it doesn't matter if you're a pro se plaintiff. Some extra lenience might be given to you, but if you can't follow the rules, a judge is going to tell you tough shit. Plaintiff filed a motion to file a second amended complaint, which the court denied on June 30th. The plaintiff is permitted to file a motion to do so. This backdrop, the court agrees plaintiff has failed to demonstrate good cause for a 90-day extension. Pursuant to court rules, a party may file a non-dispositive motion, must certify that the party has made good faith attempt to obtain the opposing party's agreement to the required relief. Plaintiff failed to meet and confer with FINRA, which you're supposed to do. I know a lot of people we talk law a lot on this channel along with finance because the two cross the streams a lot. When you have a dispute, to save the court time, you have what's called a meet and confer. You try and meet with the other side and resolve it without having to get the court involved. He failed to do that. So, tough noogies. FINRA has absolute immunity from plaintiff's claims, as we've discussed. Claims for damages is not a state actor for purposes of satisfying the requirement. Therefore, any such amendment would be futile. And notice, he did a note order ruling. He did a whole, just minute order ruling right onto the docket. He didn't even waste time with an official, order filing. Which should really show you the merits of Trout's case in this situation. Let's see if there's any updates in the bankruptcy before we get too far along here. Go away. So yeah, the hearing was rescheduled. So the original judge that was on this bankruptcy on the bankruptcy for metamaterials recused themselves before the hearing with Troud and their whole group, and therefore the new judge on their hearing has been kicked out to October 16th, along with, I believe, where the hearing was rescheduled for the subpoenas and all that shenanigans. So that'll be fun. Both the Depository Trust, FINRA, and all them are disputing in Rollo's case the additional authorities. Let's take a look at why. Defendant, Financial FINRA. Let's just call it FINRA. Submits this response to Plaintiff Jason Rollo's Notice of Supplemental Authorities, where Rollo provides the court with notice of the recent decision in National Association of Private Fund Managers, I assume, versus SEC. First, the notice is effectively an unauthorized SIR reply in response to FINRA and the other defendants' motions to dismiss, each of which are fully briefed and awaiting the decision of the court. Yeah, you need to get official permission from the court to file a SIR reply. And a lot of these, like, pro se meme stock litigants love doing things to try and loophole their way around normal federal rules of civil procedure, and courts don't really appreciate that. In this circuit and others, courts have held it is improper for a notice of supplemental authorities to include legal arguments, which he did. Here, Rollo's notice includes 10 full pages of argument, not including the caption. There are sections arguing the applicability of the decision to each of the defendant's motions to dismiss, and Rollo includes citations to various other case laws and substantive arguments throughout. For these reasons alone, the notice should be stricken. Yeah, you don't get to loophole your way around to do extra filings in the court. This is done specifically to keep things fair. The movement makes their motion. The opposing party gets to file their opposition. If they so desire, they can decide that they don't want to oppose it. Then, if the moving party wants to, they can reply to the opposition. And that is it, unless the court grants SIR replies. That's it. That is the end of it. It's the same thing that if you have opening and closing arguments. One side presents their case, the other side gets to present it. With permission of the court, you can do rebuttals. Like if you have a witness on the stand, you have cross, you have direct, then you have cross. You can have recross and redirect, but at the permission of the court. Second, the decision is completely inapplicable to the case. Rollo relies on the decision to argue, with regards to FINRA's absolute immunity from liability for regulatory actions and decision making, that courts will review such actions to ensure the agency has engaged in reasoned decision making. However, Rollo fails to recognize that the decision relates to circuit court review of agency rulemaking, and the petitioner challenges two rules adopted by the SEC. The circuit court's authority to review regulatory rulemaking has no applicability to a challenge to regulatory action. This court is not even the proper forum for such review. Further, Rollo's interpretation of the decision would overturn precedent throughout the country relating to absolute immunity for regulatory action. Yet the Fifth Circuit's decision did not mention immunity from suit even once, because it's not an issue in the reviewing agency's rules. See, this is what I mean. This is why I love going over these meme stock cases, because they're absolute stupidity. Absolute stupidity. What's new in the Rollo case? Oh boy. Response in opposition. So last week, we got FINRA's motion to dismiss, which I'm not going to bore you all with. Some of you may be new to this channel, but I'll give you a brief summary to get up with everyone else. FINRA, in its rulemaking structure, they've been delegated powers by the federal government. They're what's called an SRO, a self-regulatory organization. They make rules for the securities market. They are absolutely immune from civil suit as a quasi-governmental entity. The SEC can demand that they change their rules, and the SEC has the sole regulatory power over them. Just like there's certain parts of the security law that do not grant private rights of action. Only government may bring certain claims. There are certain laws that have a private right of action. That means you can bring a civil case. And there are certain claims that do not have a private right of action. You cannot file a civil suit accusing someone of murder. Charges for capital crimes do not have a private right of action, funny enough. They're criminal laws. They only have a government right of action, a public right of action. There is no private right of action. Much like when it comes to FINRA or FINRA's decisions as a quasi-government agency, there is no private right of action against FINRA. Only the SEC can regulate FINRA as a government agency because they are a quasi-government action doing what the government would normally do if it wanted to, but it delegated that power to a non-government entity that it regulates. That's the case law on all this. That's what FINRA is going to get to in this. I'm not going to waste your time with this whole thing. I've gone over this argument multiple times before my last channel was terminated. It's pretty settled law. It's not controversial. It's not controversial unless you're some unenlightened idiot on the internet who can't read basic jurisprudence on this. Plaintiffs oppose motion for leave to exceed pages and time limit. So this against to dispositive motions are ordinarily limited by 20 pages. Plaintiff's forthcoming response in opposition addresses claim. Oh, they want to have. Oh my goodness, they want to exceed the page limit. Yikes, that's not a good sign. Who's this directed at? Response in opposition to Berta and McCabe's motion to dismiss. Oh, this one might actually have some ground to stand on. To be fair, the SEC is already suing them, so it makes their concerns the scheme of McCabe and John Berta to engineer, promote, and potentially see, this is the problem I have with Trout and his crew, Trout, Spears, and a bunch of other these MMTLP people. They remind me of the AMC Project Popcorn crew, which, if you're not aware of them, a crew of people that realize that AMC is kind of a shit co right now. And adding the kinda adjective is being generous. it needed to dilute because it had a lot of debt that it could not pay down and was going to go bankrupt. Company had its mean stock run up. They diluted the shit out of the company. Investors got kind of fucked. A bunch of people realized that, hey, that really sucks. Realized that they didn't reach the realization that normal people would, that this was a insolvent company that needed to do things to keep the lights on, or it would have gone bankrupt and liquidated all the shareholders, see Bed Bath and Beyond. Instead, it's all fraud. They got halfway there and realized that Adam Aaron kind of fleeced them, which I'll agree with. His job was to keep the lights on. He had a fiduciary duty to the bondholders, and he extracted money from shareholders to pay the bondholders. That being said, he could have just filed bankruptcy. It probably would have been better for everyone involved and gotten the same results roughly. But rather than, reach logical decisions, they kept their meme stock crazy theories about naked shorts and all that shit. And that's the problem I have with Trout's crew. Yes, they realized that John Berta, this is also where it's different from the Project Popcorn crew. Whereas Adam Aaron had morally questionable objectives. John Berta and Greg McCabe are just straight up fraudsters who sold people on a oil company that didn't have any fucking oil. But rather than just, suing the fraudsters, they still have the crazy meme stock conspiracies of evil naked shorts, FINRA screwed us, SEC isn't regulating properly, burr, 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 burr. So, here we go. This is all stuff that I generally agree with. John McCabe should, and Gregory McCabe and John Berta should be held accountable. In fact, they are. They're being sued by the SEC right now. So, I generally agree with this. And those emails are the University of Lands emails, where University of Lands basically said, you ain't drilling out any oil, so we're going to we're going to deny the extending your leases on these properties. And they knew about that. That was material information, and they didn't really get it to shareholders until it was too fucking late. So, yeah. On that one, yeah, I totally agree. I hope that the motion to dismiss is denied because, fuck John Berta and Gregory McCabe with a rusty fucking spoon. What's this one? Huh. That one doesn't work, and I don't know why. So we come to our last case, Kelly versus Financial Regulatory, and what's this? Order granting stipulated extension of time. So extension time was granted to FINRA. Opposition to motion to dismiss number DI 24. FINRA. Response and opposition to motion at 25 to stay discovery by FINRA. Okay, yeah, because they're the only defendant here. Again, this will be quick and sweet. It's FINRA. We already discussed the whole SRO situation, so that handles that. So this is why I mostly skipped it Saturday, because the FINRA stuff is really simple. You don't get to sue FINRA. It's that simple. You may not like that. Cool. Change the law. But as it stands right now, you don't get to sue FINRA. Long and short of that. I think that pretty much wraps it up. In 2 hours and 30 minutes, it's not too bad. Not too bad for one of these extra live streams, but I think that's a good place to end it. Enjoy the rest of your evening and the rest of your week. Friday, I do have a show planned. We're going to actually talk stonks. We're going to talk stocks. We're going to talk investing. I plan on having Vent Capital on. There might be a wild Tony De Niro and maybe Ocelot. I've talked to a few people. Maybe I can steal Amy and Platinum to come on as per usual, but we're mostly going to be talking stocks, investments, long-term investments is my thing. I don't know what other people are bringing. I know I'm going to be talking probably semiconductors. It's going to be interesting. You'll want to come around. And if that doesn't interest you, well, Saturday we'll be talking about the stuff we always talk about Saturday. Fraudsters, scammers, grifters, assholes, whether they be in regular finance or in the meme stock community. Whichever you prefer to listen to, you won't want to miss out Saturday. So we'll see you then. But for now, I'm going to have a great